Hey yo folks, and welcome to the show. I have good news about the Shane Kendall case. Now, I stumbled upon this case while looking for dirt on prosecutor Adrian Love. And this is a bit of a rabbit hole. I did not expect to find that. Now, there are other cases. I will get to them in due time, but this case, the more I get into it, the more infuriating it is. Yes, a person lost its life due to Shane's actions. There's no way around that. But Shane Kendall, autistic boy, diagnosed with ADHD, schizophrenia with hallucinations. What happened in that home is hard to know. We know that his adoptive parents split up. He was at his adoptive mother's house, where her new boyfriend just let guns laying around without anything. I'm just leaving it out, loaded. And we also know that Shane Kendall's adoptive mother didn't care about getting Shane his medications. So there's a recipe for disaster. So for some reason, Shane took the gun, and then Shane's adoptive mother was gone. And what happened then was, instead of treating this like a tragic accident, Fulton County District Attorney's Office decided, through Adrian Love, to prosecute this as murder one. As if this boy could actually plan these things. They had a competency hearing. For some odd reason, Georgia holds competency hearings in front of jurors, which is ridiculous. Absolutely ridiculous. I understand having a jury at trial to be tried by your peers and everything, but competency hearing for me is something completely different. That is doctors and lawyers trying to get to a conclusion. And despite Miss Love claiming everything was faked by Shane, she had no basis for it at all. Because even the state's own doctors said, no, this boy is severely mentally ill. But that first competency hearing, hung jury. She could have left it at that. Okay, back to hospital for treatment. But no, another competency hearing where she ramped up her antes, and the jury found, this autistic, ADHD, schizophrenic boy whose adoptive mother didn't control his medication. Yeah, he's competent. How did they reach that conclusion? Well, Shane was trained in the mental place of sorts, how to answer a specific question, and if he got the answer right, he got a cookie. And then they decided, we have trained him enough. No, that is how you train dogs. And if you have to train a boy as you train dogs with treats, there's something really, really wrong with that system, in my opinion. And so Shane passed away. in Fulton County Jail through incompetent medical personnel, through incompetent prison guards, and because of underfunding. So not only is the prison underfunded, then they take on a medical, private for-profit medical thingy. They pay them $33 million a year, and they sent in people who didn't care. So in the fall of 2023, Shane's father, individually and as administrator of the estate of Shane Kendall, sued. And, of course, Fulton County, Georgia, tried to get it dismissed. And this is the decision from the judge. United States District Court, Northern District of Georgia, Atlanta Division. Harold Joseph Kendall, individually and as administrator of the estate of Shane Miguel Kendall, plaintiffs, versus Fulton County, Georgia, et al. There's a bunch of people in that lawsuit. Order. This matter is before the court on two motions. Defendant Fulton County and Sheriff Patrick Labatt's motion to dismiss, and defendants NavCare, Michael Agay, Edith, motion to dismiss, all five collectively the moving defendants. This court finds as follows. Factual background. The instant case brought by Harold Joseph Kendall, Joe, individually and as the administrator of the estate of Shane Kendall, arises from the death of the decedent on February 1st, 2021, while housed in Fulton County Jail as a pre-trial detainee. Remember, people in jail are presumed innocent. On the morning of the death, at approximately 6:10 a.m., jail staff found the decedent in his cell, slouched over with a bedsheet tied to his bunk and around his neck, unconscious from apparent self-ending attempt. Upon discovering the decedent, jail staff put out an emergency call to the on-site medical providers at approximately 6:11 a.m., requesting immediate medical assistance for, quote, an unconscious breathing inmate. Yeah, Shane was still alive at 6:11. At this time, defendant NavCare was contracted with Fulton County to provide medical services at Fulton County jail facilities. Pursuant to its contract with Fulton County, NavCare hired personnel to provide medical services in jail, including emergency medical care and mental health services. Defendant Edith, a registered nurse, and Michael, a certified physician's assistant, collectively the medical provider defendants, were two NavCare medical providers on duty in the jail when the decedent was found. Edith answered the jail staff's emergency call for immediate medical assistance. Upon receiving the call, she attempted to contact Michael, but Michael did not respond. He was on the facility. Maybe he was asleep. Maybe he was in the, pure speculation about why he chose to not answer the call. The important thing here is he didn't. Edith initially chose to wait for Michael before responding to the call herself. However, after a jail officer suggested she respond without him, Edith began, quote, casually walking towards descendant's cell. Now, this is the allegation from Joe, but we also know there is actual surveillance video of this, of her just casually walking. Edith arrived at the decedent's cell shortly after 6:16 a.m. So 5 minutes instead of. We learned why she just casually walked. But if somebody is in acute need of medical care, why walk? By this time, Yale staff had cut the decedent down from his bedsheet and had begun performing CPR to some degree. As it seems, the guards were not trained at all in providing CPR. Quote, sporadic, inadequate, inconsistent CPR was performed by the Yale staff as they waited for medical providers to arrive. Edith refused to provide any medical treatment to the decedent, including but not limited to checking his breathing, checking his pulse, ensuring his airways was clear, administrating CPR. Medical personnel, this nurse, refused to treat Shane. Around this time, the decedent stopped breathing and was unresponsive. Michael arrived at the cell at 6:22, 16 minutes later, walking at a slow to normal pace. Upon his arrival, Michael walked in and out of the cell several times before beginning to prepare an automated external defibrillator, an AED, for use on decedent. So in 16 minutes, Edith did nothing. After 16 minutes, Michael shows up and is fumbling with the AED. While Michael was preparing the AED, jail staff directed Edith to provide emergency medical air to decedent. Remember, this is 16 minutes. She's been there for 16, 17, 18 minutes at this time. She again declined, informing jail staff that she had a bad knee and didn't want to bend over to assist decedent. Edith, you're paid to do a job. You refused to do your job. At 6:24 a.m., now we are 18 minutes. Let's see, 6:11. Yeah. Yale staff instructed Michael to take over CPR efforts. However, after Michael attempted CPR, Yale staff observed that he was utterly incapable of performing the task. So you have one certified nurse and one assistant whatevers, and neither one refuses and the other one can't. And this goes back to NavCare. Why do they hire incompetent personnel? Well, money. That's a simple reason. If you want to have higher profits, you hire people who don't get paid. You hire incompetence. Remember to hit that thumbs up while you're here. That would be very, very nice. At 6:25, 40 minutes after the initial emergency call, Michael brought an AED into the cell, at which point no shock was advised. Now, an AED machine is something you strap on the person, and the machine tries to find, okay, what am I supposed to do? The machine. If you do that wrongly, for some reason, the machine can't. It will show, I can't do this. So apparently, this Mr. Michael, may or may not even know how to administer an AED. I know how, because I'm trained to do it. I do labor law. I'm a union contracted. I mean, I know how to administer an AED. We train all, well, not all, but the people who want to be certified as first responders inside a factory, for instance. You have certain people who are the first if there's a fire, who is first if there is a medical need. We train those. Well, not me, but we hire in people to train us. But NavCare, who is supposed to provide this, they apparently don't even train their own personnel in this. Hello, Sylvia. Hello, Diago, Gwendolyn. I saw Teresa a bit earlier. Jack, Matt. Hello and welcome, everybody. According to expert affidavits provided by plaintiff, the decedent's death was avoidable to a reasonable degree of medical certainty and resulted from errors made while providing this decedent with emergency medical care. And here, number 2 here. Labatt's concerns about poor jail conditions and inadequate funding. Now, Mr. Labatt has for years screamed at the Fulton County, we need better funding. Now, he is in this lawsuit because of his position, not because he necessarily did something wrong, but he is in the position of Fulton County Sheriff. So that is why he is in this. But let's read here. As Fulton County Sheriff, defendant Labatt was responsible for the jail operations, including the provision of medical care to inmates. Funding for operations is determined by the Fulton County Board of Commissioners. Around the time of the decedent's death, the jail was overcrowded, underfunded, and understaffed, which plaintiff contends resulted in the provision of inadequate medical care. Sheriff Labatt recognized the jail's problems with underfunding, and during a public meeting with the board in January of 2021, expressed an urgent need for additional funds. Plaintiff alleges that during this meeting, Labatt warned the board that more funds were necessary in order to fulfill Labatt's constitutional obligation to the inmates in the jail. My theory is that the Board of Commissioners actively underfunds Fulton County Jail, not only to save money, but to make the conditions as harsh as possible, which makes it easier for the prosecution to hand out plea deals. And admitted his inability to protect and supervise inmates, especially mentally ill ones. Labatt further stated that without additional funds and space, the conditions could be a life or death situation for thousands of people. Number 3 here. NavCare and inmate deaths at Fulton County Jail. Plaintiff alleges NavCare maintains various practices at the jail that, taken together, constitute a custom or policy of providing inadequate medical care to inmates, which has resulted in several deaths like the decedents. Now, NavCare probably don't have in their protocol or their policies that be lazy, do nothing. They probably have decent policies, but the actions over time is equal to an actual policy, even though it's not an written down policy. Plaintiffs contends that since NavCare became the medical provider at the jail in 2018, the number of inmate deaths has steadily increased. Plaintiffs alleged that in 2020, NavCare had the highest nationwide death rate among the top 5 jail healthcare providers. Plaintiffs also asserts, here we have the footnote here. The practices that are equal to policies. These practices include, among other things, 1, too few qualified medical providers in the jail. 2, inadequate training and supervision of medical personnel. 3, inadequate space and resources for medical personnel. 4, medical providers being physically and or mentally unfit to provide adequate medical care. 5, inadequate responses to medical needs. And 6, a failure to comply with emergency care standards. And yeah, you have one who refuses to do CPR because she has a bad knee, and the other one can't even use an AED properly. Plaintiffs also asserts a disproportionality high number of deaths at the jail when compared to other prisons, alleging that in 2022, the jail experienced almost the same number of deaths as a prison containing 33 times as many inmates. Yeah, there are prisons around in Georgia that has 20,000 inmates, 30,000 inmates. Or nationwide, there are prisons which with higher numbers than that. And Fulton County Jail has the same amount of deaths as a prison with 40,000 inmates. And they have, 3,300. Plaintiff further states that an internal NavCare report from 2022 issued in response to jail deaths describes the jail's widespread neglect of mentally ill inmates in particular. Moreover, plaintiff alleges 5 specific inmate deaths at the jail, 2 in 2019 and 3 in 2022, that he maintains resulted from NavCare's practice of failing to provide adequate medical care to inmates. Plaintiff argues that the actual number of jail deaths caused by NavCare's inadequate medical care is likely larger, but because most jail deaths and their surrounding circumstances are not publicized, they are difficult to discover without litigation. Further, plaintiff asserts that despite knowledge of the jail's serious issues and prior deaths, NavCare failed to make necessary corrections to its practices and to avoid continued constitutional violations. Procedural history, well, this is... We don't need that. They filed a suit, they allege. Legal standard, at the motion to dismiss stage, all well-pleaded facts are accepted as true, and the responsible inferences therefrom are construed in the lights most favorable to the plaintiff. Bryant v. Avado Brands, 1999, 11th Circuit. So it is really it's really hard for the defendants to get dismissed, because as long as the facts are well pled, they are accepted as true. So the plaintiffs is in a good position to start with. In determining whether an action should be dismissed for failure to state a claim, Federal Rule of Civil Procedure provides that a pleading must contain, quote, a short and plain statement of the claim showing that the pleader is entitled to relief. The pleading must contain more than labels and conclusions or a formulaic recitation of the elements of a cause of action. Importantly, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Detailed factual allegations are not necessary. A plaintiff's statements need only give the defendants fair notice of the plaintiff's claim and grounds upon which it rests. Here is the judge's analysis. NavCare, Egway, Michael, and Edith motion to dismiss. Let's see here. Against NavCare and the medical provider's defendants, plaintiffs have brought two claims under that thing based on an alleged violation of the decedent's constitutional rights under the 14th Amendment, counts 5 and 6. NavCare and the medical provider defendants move to dismiss both counts 5 and 6 on the grounds that plaintiff have failed to state a claim on which relief can be granted. They also argue that the plaintiff's amended complaint constitutes an impermissible shotgun pleading in violation of Rule this, making it subject to dismissal. The court considers these arguments in turn. A. Sufficiency of claims against the medical provider defendants. The court will first analyze the claim against medical provider defendants, count 6. Generally, the requirements of a 1983 claim are 1. The conduct complained of was conducted by someone acting under the color of state law, and the conduct deprived the plaintiffs of legally recognized or constitutional rights, privileges, or immunities. Violation of a constitutional right. As stated above, a constitutional claim brought pursuant to 1983 must begin with the identification of a specific constitutional right that has allegedly been infringed. Here, plaintiff contends that the decedent's constitutional rights under the 14th Amendment were violated due to the medical provider defendant's deliberate indifference to decedent's serious medical need. It is well settled that prison officials' deliberate indifference to a prisoner's serious medical needs give rise to a constitutional claim. In Harris v. Covina County, see also Hill versus Clayton County. And here's another footnote. Upon review of both motions, no moving defendant has moved to dismiss plaintiff's case on the grounds that the defendant was not acting under the color of state law. Therefore, the court will focus its 1993 analysis on whether the alleged conduct deprived the decedent of a constitutional right. And under the 14th Amendment, a pretrial detainee, like decedent, is afforded the same rights as would be available to a convicted person under the 8th Amendment. To establish deliberate indifference to a serious medical need, a plaintiff must show 1. A serious medical need, 2. Deliberate indifference to that need, and 3. Causation between that indifference and the injury. Yes, Sylvia. In Fulton County Jail, they found an inmate more or less eaten alive by bedbugs. That is the state of Fulton County Jail. 1. Serious medical need. A serious medical need is, quote, one that has been diagnosed by a physician as mandating treatment, or one that is so obvious that even a layperson would easily recognize the necessity for a doctor's attention. Yeah, a person hanging from the neck, still breathing. You need to be a complete moron to not realize, oh, we should provide medical care. Alternatively, a serious medical need may be determined by whether a delay in treating the need worsens the condition. Yeah. The essential inquiry is whether the need is one that, if left unattended, poses a substantial risk of serious harm. Shane was still breathing when Edith arrived, and she refused to provide medical care because of a bad knee. Here, plaintiff alleges that jail employees observed the decedent slouched over in his cell with a bedsheet tied to his bunk and around his neck. In their call for emergency medical assistance, jail staff described him as, quote, an unconscious, breathing inmate who had apparently attempted self-ending. The decedent's condition at the time, and at the time he was found, clearly required immediate medical attention. This much would be clear to anyone. This is the judge writing this. Moreover, as the situation progressed, the decedent stopped breathing and became unresponsive. Such facts demonstrate a medical need so obvious that any layperson would easily recognize the necessity for a doctor's attention, and that delay in treatment would pose a substantial risk of serious harm. Plaintiff sufficiently alleged the existence of a serious medical need. Number 2, deliberate indifference. Still on the judge's analysis of this. Moving to the next prong of the analysis, plaintiff must, quote, allege acts or omissions sufficiently harmful to show deliberate indifference to serious medical needs. To constitute deliberate indifference, a plaintiff must allege 1. Subjective knowledge of a risk of serious harm, 2. Disregard of that risk, and 3. Conduct that is more than mere negligence. To establish subjective knowledge, the defendants must both be aware of facts from which the inference could be drawn that a substantial risk of serious harm exists, and must also draw the inference. Whether the medical provider defense had this level of subjective knowledge, quote, is a question of facts subject to demonstration in the usual ways, including inference from circumstantial evidence, and the fact finder may conclude that a prison official knew of a substantial risk from the very fact the risk was obvious. Here, Edith, a registered nurse, received an emergency call reporting an unconscious breathing inmate who had apparently attempted self-ending. She then arrived at the cell and personally observed the inmate. During this time, the decedent became unresponsive and stopped breathing, and jail staff instructed Edith to provide emergency medical aid. Michael, a certified physician's assistant, also arrived at the decedent's cell and had opportunity to observe the decedent in his very serious state. Michael was likewise instructed to perform, and indeed attempted to perform, CPR on the decedent due to his critical condition. Under such facts, plaintiff has sufficiently alleged the medical provider defendant's subjective knowledge of a risk of serious harm. Next, the court considers whether plaintiff have plausibly pleaded that the medical provider defendants disregarded the decedent's risk of serious harm by conduct that is more than mere negligence. The 11th Circuit Court of Appeals has instructed that deliberate indifference may be demonstrated by a showing of grossly inadequate care, or when the need for treatment is obvious medical care, which is so cursory as to amount to no treatment at all. Moreover, when acts or omissions result in an unnecessary and wanton infliction of pain or are repugnant to the conscience of mankind, they constitute deliberate. Deliberate indifference may also arise from a delay in medical care that is tantamount to a necessary and wanton infliction of pain. Although some delay in medical care may be tolerable, whether it is tolerable depends on the nature of the medical need and the reason for the delay. Notably, quote, a delay in care for known unconsciousness brought by asphyxiation is especially time-sensitive and must ordinarily be measured in a few minutes. Taken as true and viewed in a light most favorable to plaintiff, the following occurred. Edith, having received an emergency call for immediate medical assistance, did not immediately respond to it. She instead attempted to contact Michael and initially opted to wait for him before responding. Following some delay, and after jail staff suggested she not wait, Edith began casually walking to the cell upon her arrival. However, Edith refused to provide any medical treatment whatsoever to the decedent, despite being obligated to do so by NavCare's contract with Fulton County. I agree, GD. Deliberate indifference should be charged manslaughter. Yeah. Even after the decedent had become unresponsive and stopped breathing, and after jail staff directed her to assist, Edith still declined to provide medical care to the decedent, apparently indicated her, quote, bad knee prevented her from rendering aid and informing jail staff that she did not want to bend over. I have bad knees. I have arthritis in both. It would hurt my knees to provide medical care. So what? Me having a half day of knees hurt and a person might survive, I would perform CPR. I'm not even a medical person. I'm just a junior rep. But this certified nurse, lazy Edith, oh, I have a bad knee, I don't want to bend over. You're getting paid to do medical care. If you can't provide medical care, get the fuck out. And be replaced with a person who might actually want to do their job, you lazy piece of garbage. That is not the judge's analysis. That is my analysis. I have to point that out. For if persons with hard of seeing is listening in, that was my commentary. Judges normally is less colorful in their language. According to the amended complaint, at no point did Edith provide medical assistance to the decedent. Such facts, taken as true, constitute medical care, which is so cursory to an amount to no treatment at all. Moreover, even construed as only a delay in the decedent's medical care, since Edith ultimately appeared to assist, the nature of the decedent's medical need was dire, and the alleged reasons for Edith's delay, preferring to wait for a colleague and a bad knee, plausibly show that Edith's delay was intolerable and tantamount to unnecessary and wanton infliction of pain. Thus, plaintiff has sufficiently pleaded that Edith disregarded the decedent's risk of serious harm by conduct that is more than mere negligence. So, Edith still on the hook. Turning to Michael. Plaintiff alleges that he failed to respond to the initial emergency call for 11 minutes. When he arrived, he was walking to a slow to normal pace. After his arrival, when directed by a jail officer to take over CPR, Michael attempted to administer CPR, but was, quote, was utterly incapable of performing that task, end quote, such that the jail staff instructed him to stop and let jail staff switch in instead. Although the amended complaint indicates no reason for Michael's substantial delay, the delay itself in response to the decedent's, quote, especially time-sensitive, end quote, condition indicates deliberate indifference. Moreover, plaintiff has alleged that once Michael did arrive, he was incapable of basic emergency medical care and so inferiorly equipped that jail staff had to intervene. As such, the facts as pleaded constitute, quote, grossly inadequate care, end quote, demonstrated that Michael disregarded the decedent's risk of serious harm by conduct that is more than mere negligence. Michael still on the hook. Thus, plaintiff has sufficiently alleged deliberate indifference by the medical provider defendant. 3. Causation. Finally, causation between the defendant's deliberate indifference and the injury requires, quote, proof of an affirmative causal connection, end quote, between the state actor's conduct and the constitutional violation. a state actor's personal involvement in the acts resulting in the constitutional violation can establish the requisite causal connection. Plaintiff alleges that the medical provider defendant's delayed and inadequate medical care resulted in decedent's death. Moreover, plaintiff attached to his amended complaint 2 affidavits of medical experts indicated that decedent's death could have and likely would have been avoided if not for the multitude of errors in provided emergency medical care to decedents. Thus, plaintiff had plausibly alleged an affirmative causal connection between the medical provider defendant's acts and omissions and decedent's death. Based on the foregoing, plaintiff has sufficiently pleaded a 1983 claim for deliberate indifference to serious medical need against the medical provider defendants. Then you go into sufficiency of claims against NavCare. The court next analyzes plaintiff's claim against NavCare. Count 5. When a private entity like NavCare contracts with the county to provide medical services to inmates, quote, it performs a function traditionally within the exclusive prerogative. Sorry, folks, I'm Swedish. Your words are hard sometimes. Prerogative of the state and becomes the functional equivalent of the municipality. A municipality, or, as in the case of NavCare, its functional equivalent, is not liable under 1983 on the basis of respondent superior. Rather, it is properly subject to suit only when the municipality had a policy or custom that inflicted the constitutional injury. So here they have an actual hurdle to overcome, the plaintiffs. Thus, in order to state a claim for relief against NavCare, plaintiff must, in addition to showing that decedent's constitutional rights are violated, establish 1. That NavCare had a custom or policy that constituted deliberate indifference to decedent's constitutional rights, and 2. That the policy or custom caused the violation. In quote, in order for a plaintiff to demonstrate a policy or custom, it is generally necessary to show a persistent and widespread practice. A policy is a statement or other decision, quote, officially adopted and promulgated by a government or its officers, while a custom receives no such formal approval through official decision-making channels. A custom, rather, is, quote, a practice that is so settled and permanent that it takes on the force of law. Because a municipality would rarely have an official policy that endorses a constitutional violation, most plaintiffs must show that the municipality has a custom or practice of permitting it. To show this, a pattern of similar constitutional violations is ordinarily necessary. Here, plaintiffs alleges that NavCare knowingly promulgated, enforced, and allowed to persist a series of policies and procedures in the jail that collectively constituted widespread practices that resulted in their failure to adequately provide mental health treatment and emergency medical services to inmates in jail. This is a long one. Plaintiff's primary theory of liability then appears to be that NavCare had an overall custom or policy of failing to provide adequate medical care. Plaintiff contends that several NavCare practices demonstrate this custom or policy: 1. Understaffing; 2. Failing to perform intake procedures correctly; 3. Auto-populating psychiatric progress notes without evaluation. That means they rubber stamp that they have assessed the inmate without actually meeting them, which shouldn't happen. Four, providing insufficient space for adequate medical care. 5, under-resourcing. 6, failing to train and supervise its medical personnel. 7, failing to provide adequate responses to emergency medical needs of inmates, including attempted self-endings. 8, employing medical providers who are physically and/or mentally unfit to provide medical care to inmates. 9, failing to adhere to accepted standards of emergency medical care. And 10, failing to provide adequate emergency medical services to inmates in serious need of medical attention. Plaintiffs also alleges, here we have a footnote 3. The court notes that certain of these discrete practices under the right set of facts may alone constitute a custom or policy of deliberate indifference to a constitutional right. However, in the instant case, plaintiff does not appear to plead those practices as separate constitutionally informed policies or customs. Rather, plaintiff's amended complaint states that they collectively constitute a widespread practice, i.e. a custom or policy, of providing inadequate care to inmates. Thus, the court will not consider the sufficiency of each individual practice under a monal theory of liability. I'm not entirely sure what that means. You in the chat, if someone in the chat can inform me, I will be so happy. Plaintiff also alleges that at least 5 other jail deaths in the years surrounding the decedent's death were likewise caused by NavCare's failure to provide adequate medical care. Moreover, plaintiff states that NavCare had the highest nationwide death rates among the top 5 jails healthcare providers in 2020, and a disproportionately high number of inmates' deaths when compared to much larger institutions in 2022. Footnote 4 and 5. The long one. Footnote 4. Plaintiff further contends that, following discovery, he will likely uncover additional similar incidents of inmate deaths, but that additional examples of NavCare's failure to provide inadequate medical care resulting in inmates' death are, quote, hard to discover, because most jail deaths are unpublicized, and records related to those deaths or showing instances of inadequate medical care often require litigation. Yeah, so this is them getting to discovery. Footnote 5. Specifically, plaintiff alleges that in 2022, New York's Rikers Island, with an inmate population of 100,000, had 18 inmate deaths, while the jail, with an inmate population of 3,000, had almost as many in the same year, 14. Plaintiff contends that such an astonishing, shocking inmate death rate when compared to other larger detention facilities is further evidence of defendant NavCare's inability to provide adequate medical care to inmates in the jail. There are 100,000 inmates in Rikers? Jesus Christ. Sylvia says, it's a separate discussion in the chat now about. She says, I believe Fanny received money to help clear the backlog that she mishandled. Yes, she got a boatload of money to clear the backlog. And she chose to use that money for 5 RICO trials. I will get in. There are so much about Fulton County that it's hard to do it by myself. I hope when it comes, I will do more about Fannie Willis, more about the Fulton County Jail, but my main focus is the Young Thug trial. I will try to make more of these as we go along, but I'm just one person. But if you wouldn't mind, like, subscribe, share on social media, and stuff like that. That helps me get the word out, so to speak. Let's see here. Taking these allegations as true, plaintiff has sufficiently alleged that NavCare has a policy or custom of providing inadequate medical care to inmates, constituting deliberate indifference to their constitutional rights. In addition to stating several specific objectionable practices that make up NavCare's custom of failing to provide adequate medical care, plaintiff has asserted other jails' deaths allegedly due to that custom, as well as a disproportionately high number of deaths at the jail when compared to other prison and jail healthcare providers. And Thank you, Cat Not Williams. Thank you so much. Gifting 10 memberships. That is awesome. Thank you so much. It was gifted to Liam 007, TG, JB, Marjorie Smith, Jess Rubery, Culperistic, Chris Pounton, JD Fan, Jesse Hansen, and David Rook. Welcome to the show. Welcome to Vikings saying hi. You now have access to all my members only content, and it's a lot of it. You will never run out of things to watch. Now, my members only content is more me, personal stuff like the farm, the renovations, my tractor, I mean stuff like that, and personal thoughts. So welcome. Thank you so much, Cat Not Williams. Where were we? Having concluded that plaintiffs sufficiently allege the existence of a municipal policy or custom constituting deliberate indifference to a constitutional right, the court turns to causation. To prove causation on the Monell, a plaintiff must show the policy or custom was the moving force behind the constitutional violation. As already discussed, plaintiff has sufficiently alleged that a medical defendant's provision and adequate medical care resulted in decedent's death. Having also sufficiently alleged the existence of NavCare's custom or policy of providing inadequate medical care, which resulted in the medical defendant's actions, causation is plausibly established. Taken as true, plaintiff has alleged sufficient facts to show that NavCare alleged policy or custom was, quote, the moving force, end quote, behind the constitutional violation at issue here. For these reasons, plaintiff 1983 claim against NavCare may proceed. C. Alleged shotgun pleading. NavCare and the medical provider defendants also argue that plaintiff's amended complaint is an impermissible shotgun pleading, which should be dismissed in its entirety. Quote, courts in the 11th Circuit have little tolerance for shotgun pleadings, which violate Rule 8's requirement that a complaint contain a short, plain statement of the claim. Typical shotgun pleadings are characterized by any one of the following. 1. Multiple counts that each adopt the allegations of all preceding counts. 2. Conclusory, vague, and immaterial facts that do not clearly connect to a particular cause of action. 3. Failing to separate each cause of action or claim for relief into distinct counts. Or 4. Combining multiple claims against multiple defendants without specifying which defendant is responsible for which act. Here's this case. These categories do not have precise and clearly marked boundaries. In this case, talk about significantly the unifying characteristic of all shotgun pleadings is that they fail to give the defendant adequate notice of the claims against them and the grounds upon which each claim rests. NavCare and the medical provider defendants argue that the amended complaint is a shotgun pleading because it reincorporates preceding paragraphs of the amended complaint. The amended complaint twice reincorporates all previous allegations. However, such reincorporations do not, quote, materially increase the burden of understanding the factual allegations underlying each count in the amended complaint. Defendants additionally argue that the amended complaint is a shotgun pleading because it contains conclusory and vague allegations. The court finds that the amended complaint is not so plagued by conclusory, vague, or immaterial facts that the pleading subject to dismissal in its entirety. However, the court is of the view that count 2 of plaintiff's amended complaint, claims against Sheriff Labatt in his individual capacity, contains the types of deficiencies often found in impermissible shotgun pleadings. The court discusses this issue below. So in count 2, the judge has some issues. Fulton County and Labatt's motion to dismiss. Plaintiff also brought claims against Fulton County and Sheriff Labatt in his individual capacity, as in his position. Pursuant to that code, these claims are likewise based on the alleged violation of decedent's constitutional rights under the 14th Amendment. Fulton County and Sheriff Labatt moved to dismiss plaintiff amended complaint on the grounds that 1, fails to allege all material elements necessary to sustain recovery for their claims, and 2, Sheriff Labatt is entitled to qualified immunity. A here, sufficiency of the claim against Fulton County. The same Monell standard applicable to NavCare also applies to Fulton County. As discussed previously, plaintiffs must show 1, violation of a constitutional right, 2, that the municipality had a custom or policy that constituted deliberate indifference to that constitutional right, and 3, that the policy or custom caused the violation. As discussed above, plaintiff has sufficiently alleged a constitutional violation based on the medical provider's defendant's deliberate indifference to decedent's serious medical need. The court next must examine whether plaintiff has sufficiently alleged the existence of a Fulton County policy or custom constituting deliberate indifference to that constitutional right, and the causal relationship between the policy or custom and the constitutional violation. Here, plaintiff alleges that Fulton County had a persistent and widespread practice of underfunding the jail so as to deny decedent's constitutional rights. In the context of budgeting decision, a plaintiff must show that the constitutional violation complained of is a highly predictable consequence of the budgeting practice. Highly predictable consequence is, for instance, drunk driving. It is a highly predictable consequence that you will cause accidents of some sort. Or the highly predictable consequence of if you raise a knife against someone and do a forward motion, its highly predictable consequence is that the other person might get hurt. That is a highly predictable consequence. Here it is, the claim from the plaintiffs is that the budgeting practice of not allocating funds to the jail causes these things. To make such a showing, a plaintiff must allege facts sufficient to identify a pattern of injuries linked to the budgetary practice and establish that, quote, a reasonable member of the decision-making body would conclude that the budget decision would lead to the constitutional violation at issue. Here, plaintiff asserts that Fulton County has, quote, a long, troubled history of providing inadequate funding for operations at the jail. Plaintiff further contests that Sheriff Labatt, since taking office in January of 2021, has recognized this problematic practice and had made continued pleas to Fulton County for additional funding for the jail, communicating his profound safety concern for inmates in the jail. Indeed, plaintiffs allege that less than 2 weeks before the decedent's death, Sheriff Labatt specifically told the board that without additional funding, he would be unable to fulfill his constitutional obligations to provide adequate medical care to inmates. At this meeting, Labatt, quote, described the deplorable conditions in the jail and admitted his inability to protect and supervise inmates, especially mentally ill ones, because the jail was overcrowded, understaffed, and underfunded. Plaintiff alleges that while pleading for funding at the jail, Labatt acknowledged that if funding were not increased, it could result in serious danger for inmates, saying, quote, I'm walking in a space where lives are at risk, and, quote, it could be a life or death situation for thousands of people. In short, viewing the alleged facts and making reasonable inferences in a light most favorable to plaintiff, Sheriff Labatt warned the board of his specific concern that continued underfunding would result in inadequate medical care for inmates, especially mentally ill ones. Moreover, plaintiffs have also identified a pattern of injuries, jail deaths, between 2019 and 2022, that he alleges are linked to the board's decision not to increase funding for the jail because the decision led to the continued provision of inadequate medical care. Viewed in this light, plaintiff has sufficiently alleged that Fulton County had a persistent and widespread practice of underfunding the jail, and that a reasonable member of the board would conclude that its decision to continue underfunding would lead to a violation of inmates, or in particular, mentally ill inmates' rights to receive medical care. Causation. To prove causation under Monell, a plaintiff must show policy or custom was the moving force behind the constitutional violation. And yeah, that's the same as before. For the same reason already discussed, viewed in a light most favorable to him, plaintiff has alleged sufficient facts to show causation. As described in more detail above, Labatt spoke directly to the board before the decedent's death and alerted the board to his inability to meet his constitutional obligations to the jail's inmates at existing funding levels. Labatt described his inability to protect inmates, especially mentally ill ones, stating that, quote, lives are at risk, end quote, and that the matter was an issue of life or death. Due to Fulton County's decision to continue underfunding the jail, despite Sheriff Labatt's specific warnings, one can reasonably infer that the jail deficiencies Sheriff Labatt warned about persisted and ultimately resulted in the inadequate medical care provided to the decedent, resulting in his death. Viewed in a light most favorable to plaintiff, such facts plausibly state that the board's budgeting decision was, quote, highly likely to inflict decedent's alleged constitutional rights violation, deliberate indifference to his serious medical needs. Thus, plaintiff has sufficiently alleged a Monell claim against Fulton County. Sufficiency of claims against Sheriff Labatt. The nature of the plaintiff's 1983 claims against Sheriff Labatt are difficult to decipher. In count 2 of the amended complaint, plaintiffs allege that Labatt is liable under 1993 for the constitutional violations of his subordinates. Supervisory liability can establish when, quote, the supervisor personally participates in the alleged constitutional violation, or when there is causal connection between actions of the supervising official and the alleged constitutional deprivation. Here is the footnote 7. In reviewing plaintiff's alleged facts, the court recognizes that it is not clear what specific issues Sheriff Labatt was concerned about when communicating to the board. However, given that plaintiff alleges that inmates' lives were at stake, in conjunction with plaintiff's other allegations about the provision of inadequate medical care at the jail during this time, a reasonable inference can be drawn that Sheriff Labatt's concerns regarding underfunding and understaffing related to inadequate medical care. That said, whether Labatt's warning to the board did in fact specifically concern inadequate medical care for inmates, such as decedent's constitutional violation, would have been a, quote, plainly obvious consequences of the board's budgeting decision, is an allegation that may ultimately be refuted through discovery. So we go back to this discovery thing. Let's see. In his amended complaint, plaintiff alleges both Sheriff Labatt's personal participation in the violation and causal connection to the same. In attempting to show a causal connection, plaintiff alleges various jail deficiencies of which Sheriff Labatt was aware or permitted and failed to correct. However, in his response to Fulton County and Sheriff Labatt's motion to dismiss, plaintiff does not appear to address this claim for relief. Indeed, plaintiff's response is devoid of argument regarding Sheriff Labatt's alleged personal participation, and apart from a vague reference in a section heading, appears to contain no argument of causal connection either. Rather, in his response, plaintiff argues deliberate indifference based on Sheriff Labatt's failure to train employees in emergency medical care. A failure to train claim for relief is separate from the 1983 supervisory liability claim that plaintiff alleged in his amended complaint, and it implicates a different rule. This case is discussing the different test for the plaintiff's alternative claims for relief, supervisory liability based on a causal connection and failure to train. Although the court acknowledges that the plaintiff included certain factual allegations in his amended complaint, and specifically in the count against Sheriff Labatt that may relate to a, quote, failure to train claim, it is not clear from the pleading that such factual allegations are being offered as an alternative claim for relief. In this way, plaintiff claims against Sheriff Labatt contain deficiencies consistent with those typically found in shotgun pleadings. Indeed, it appears that plaintiff's pleading as to Labatt, quote, commits the sin of not separating into a different counts each cause of action or claim for relief. As a result, plaintiff have failed to give defendant Labatt adequate notice of the claims against him and the grounds upon which each claim rests, and the court is ill-equipped to evaluate the merits of plaintiff's claims. In deciding whether to evaluate certain claims when faced with a shotgun pleading, the 11th Circuit has stated, quote, we could perhaps decide whether some of these claims were subject to dismissal under Rule 12b-6, leaving for another day a decision about other claims following repleading on remand. Piecemeal education of that kind, however, does not promote judicial efficiency. Thus, this court could have declined to analyze whether any of plaintiff's claims were subject to dismissal at this stage. However, because only certain claims contained within plaintiff's amended complaint possess characteristics of a shotgun pleading, the court believes judicial efficiency is better served in this case by dismissing without prejudice. That means that when it comes, they can amend it. They can file it again. It's without. If it was with prejudice, that's the end of the line. But the judge here allows them to refile against Labatt, so that is also positive. Only plaintiff's claims against Sheriff Labatt and affording plaintiff an opportunity to amend those claims. Yeah, I should have kept reading. Thus, plaintiff will have 14 days to amend his claims against Labatt in his individual capacity. If plaintiff chooses to amend, defendant Labatt will be granted another opportunity to move to dismiss within 30 days of any potential amendment. Labatt's arguments regarding the issue of qualified immunity will be considered when the court is able to analyze plaintiff's claims against Sheriff Labatt on its merits. Conclusion. We are in the final stretch here. For the foregoing reasons, defendant NavCare Incorporated, Edith and Michael's motion to dismiss is denied. Ha! Defendant Fulton County and Sheriff Labatt's motion to dismiss is denied in part. That means Fulton County moves forward. Labatt's motion to dismiss, the plaintiffs can amend. Count 2 of plaintiff's amended complaint is dismissed without prejudice. That is count 2. So they can refile. Plaintiff may amend his complaint only as to Sheriff Labatt in his individual capacity in order to adequately plead the specific 1983 claim or claims against him within 14 days of the date of this order. If an amended complaint is filed, Sheriff Labatt may move to dismiss within 30 days after an amended complaint is filed. What's going on now? Okay, okay. Plaintiff is notified that the failure to submit an amended complaint within the 14-day period may result in dismissal of count 2 with prejudice. The clerk is directed to resubmit this matter in the event that an amended complaint is not filed. Further, Local Rule 16.2 requires parties to submit a joint preliminary report and discovery plan. Fulton County and NavCare and the two separate defendants are required to submit preliminary report and the discovery plan. As, yeah, okay, we better start. We have to give things to the plaintiffs. Information. Quote, the completed form must be filed within 30 days after the appearance of the first defendant by answer or motion, or within 30 days after a removed case is filed in this court. To date, the parties have not submitted their plan, even though the first defendant appeared in this case in February of 2023. That is not good for the defendants, because regardless of the dismissal, they should still have the plan in place. They don't have to start according to the plan, but they still have to have the plan in place. And they failed. That's interesting. The parties are hereby ordered to file the joint preliminary report and discovery plan no later than 30 days from the date of this order. Now the plaintiffs have a court order against the defendants. The parties are notified that a failure to comply with this order may result in sanctions, including dismissal. If, in the event a joint preliminary report and discovery plan is not filed, the clerk is directed to submit the case at the expiration of the applicable time period. So ordered, this 22nd day of March 2024. Now, what have happened since then? I am waiting for those documents. So this will be, I will update on this case as soon as I get the new documents. Gigi, thank you so much. You don't have to, you know you don't have to, but thank you for your $5 super chat. If sheriff isn't a medical trained person and his pleas for assistance are ignored, how can he be held accountable? It's his position. So as a supervisor of everything that goes on in the prison, he is still the top dog in making sure that others are trained. He doesn't have to be medical trained himself, but he have to make sure that his staff are. So that is why the plaintiffs, Joe is moving this against Sheriff Labatt. And yes, Fire Red podcast. If you haven't seen that show, go see it. He sadly has a diagnosis of terminal cancer, and he does need your folks' help with basic needs. So that's the link to their GoFundMe page or Give Send Go page. So Shane sadly died unnecessarily, but this lawsuit is moving forward, and they have the rate of success hard to tell at this stage. We might be a year or so away from getting towards either either an offer from the plaintiffs, from the defendants. We might be a year from what might be a trial. I don't see this going to trial. I will see if this moves forward and they have to give up discovery, and that discovery is very damning. I don't see how they will avoid trying to pay up to make it go away. But as soon as I get the new papers, I will present it to you all. But this is a good thing sadly, it's all about the money. Fulton County tried to save money. NavCare wanted higher profits. In order for them to change their ways, a lawsuit like this must succeed. Later today, I will go into a bit of the Young Thug trial. I need to get some food and stuff and prepare. But later today, I will do at least some of today's Young Thug trial. Remember, they are still at cross-examination of another gang expert in the Young Thug trial. So, what to say? I haven't put up that yet. I will do one thing. I will send you off to Friday's my birthday stream on Friday. so that you can press that button press all the buttons that the bell thingy, so you get notified when I start on Friday. But again, thank you all for showing up. Hit that thumbs up and hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Thank you. See you later. Bye-bye.